Yeah, so hi everyone. Good evening to one and all who are present for this webinar today. I have Nitish Bagri, my friend, and I'll ask him to introduce himself once we begin with the session. The session is about revamping of consumer laws in India, and we'll have a detailed discussion like why was this required and all of that, and what's the advantage of maybe having a new consumer law in place, the Consumer Law 2019. So Nitish, apart from Nitish, I would request everyone to introduce themselves in the chat so that we get to know who are present for the session. And yeah, hi Nitish, please introduce yourself.
Hi Mayur, how are you? Good to meet you again.
I am good. Yeah.
Hi everybody, I am Nitish Bagri. I am practicing in Jaipur from 2013. I graduated my law from Bharati Vidyapeeth University in 2011 and started practicing at Jodhpur. For 2 years I was in Jodhpur. I joined the chambers of Mr. Sajjan Singh Rajpurohit, senior advocate, and thereafter I shifted to Jaipur in 2013 and joined chambers of Mr. Virendra Luda, senior advocate. And in 2015, I got independent, started my own practice. And I've been practicing independently since then in various fields. Is it live? Is there some correction error?
On YouTube as well as the Zoom.
Am I audible, Mayur? Am I clearly audible?
Yes, pretty much audible. Yeah. Please go on.
Yes. So I started my own chamber in 2015, and thereafter I've been practicing appearing for government corporations, insurance companies, builders, media houses, and print media, and a lot of other state government. I've been representing government in Supreme Court as a panel lawyer from 2015 onwards. So this is the brief history in the area where I practice. So today in this session, we'll be speaking about consumer laws, how it has evolved over the period of time. What are the consumer laws from, from independence to till date. So this is the brief introductory of the session, which we'll be holding it today.
Right. So Nitish, can we just start with a brief introduction about the Consumer Protection Act 1986?
Yes. Look, before starting with the Consumer Protection Act 1986, I would bring the attention of all the viewers to the laws which were applicable prior to 1986, because that is how the consumer laws will begin, and viewers all the listeners will have a brief memory of how the things have evolved over a period of time. So, with your permission, I would like to begin with that.
Yeah, sure, please go.
Yes. So prior to 1986, post-independence, there was no specific law which used to govern the Consumer Protection Act. If the consumer was aggrieved by misrepresentation or product default, the only the option available with them was to file a suit for damages. So the suit for damages will go to the civil court, and the civil court, in the usual practice, it takes a lot of time to get things resolved. So the need was felt to establish a specific forums who would deal with the consumer issues at large. So prior to that, what used to happen was there was a suit for damages would be filed before an appropriate forum. The first appeals would go, second appeals would go, and by the time this whole litigation would end, the justice system, delivery system would fail the interest of consumers to be protected. So therefore, in 1986, this Act of Consumer Protection Act 1986, which hold grounds good today, was introduced by the government. So the Consumer Protection Act 1986 was brought into picture with five major things, keeping five major pointers in mind. First was the consumer was given five choices, that is right to choice. Right to choice means any consumer who wants to use any services or buy any product should have multiple choices. It should not be referring to one single once. There should not be less competition, and all the players should have equal right to access the market, and consumer should be given all options. Second, the consume that there should be a right against marketing of hazardous goods. So supposedly, if you have noticed that there are never advertisement of chemicals or other hazardous products on TV. Those are specifically barred under the consumer laws. So the right of consumer says that hazardous product should not be advertised. Third is that the consumer should be informed about the price, quality, quantity, ingenuity, and potency of the goods. So if you are buying a product, you should know about the quality, you should know about the quantity, you should know about the price of the product. It has to be very specifically mentioned on the product itself. If you have ever noticed, if you turn around a product which you buy from the market, there is always all things specifically mentioned. That is because of the consumer laws of 1986. Fourth is that there should be a right of consumer education. The consumer should be made well aware of. There was a specific ministry which was set up in the union as well as in the state governments, which would look into the aspects of consumers. And the consumer, there was a separate department which was created by the government, who would look into the educations of consumer. So if you have heard that there many times there are posters, and in radio and newspapers there are advertisements given by the union, by the government, specifically pointing out the rights of the consumer. That is the right of consumer education. And lastly, and the fifth point is that the consumer issues would be adjudicated at an appropriate level. So if at all a consumer is facing an issue regarding to any product or services, his grievance has to be addressed at any level, that is district level, state level, and national level. So looking into these five major pointers, the Consumer Protection Act 1986 was established. So the Consumer Protection Act 1986 gave three-tier adjudication process for the consumer issues. There was three-tier mechanism, that is first district consumer forum, second was state consumer forum, and third and lastly was national consumer forum. These three forums were established who would look into the redressal of grievances of all the consumers, and their jurisdiction was divided on pecuniary and territorial basis. So first, district consumer forum. District consumer forum would deal with, in the Act of 1986, it would deal with complaints arising to the value of up to 20 lakhs. So if there is any grievance, where the value of the goods and services is up to 20 lakhs, you would institute a complaint before the district consumer forum. Beyond 20 lakhs, if there is a dispute or if there is a grievance up to 1 crore, you would institute that complaint before the state consumer commission. And after beyond the scope of 1 crore rupees, you would institute a complaint before the national consumer commission. So these were the three tier established to address the needs of the consumer for adjudication of their disputes. So how the territorial pecuniary jurisdiction would be determined is still a question. In the Act of 1986, the pecuniary jurisdiction of the claim would be decided on the claims, on the value of the claim. So supposedly you claim a mental harassment compensation of 10 lakhs, and there is a product loss of 12 lakhs, and the total amount goes beyond 20 lakhs. So you would need to file your complaint before the state consumer commission. So these three-tier system was established for addressing the grievance of the consumers. Now, once a complaint has been instituted, it was felt that for consumer issues, and consumers should themselves approach the forum. So the method or the procedure for consumer issues was very much made easy to approach. Any consumer themselves, by writing a written complaint, can approach a district consumer forum, and district consumer forum would not be bound by the procedures or strict procedures or rules of evidence. So these all thinking of all these aspects, the Consumer Protection Act 1986 was enacted. The procedures were made simple. An appeal was made in a time bound manner, that supposedly if a person is aggrieved by the order of district consumer forum, it is either the consumer or the respondent. They can only file the appeal before the state commission within a period of 30 days. So 30 days is a very strict limitation. If you go beyond the period of 30 days, you need to explain delay of each and every day as to why there was a delay in filing the appeal. And even what you earlier used to happen was that the procedure aspect would take a lot of time. When I say procedure aspect would take a lot of time, it means that supposedly if a complaint was instituted, say in 2015, for 2-3 years the reply would not be filed. Normally this is what happens in the civil litigation. But the statutory provisions and the the act makers were aware of this problem, so they in the provision itself put a time limitation of 30 plus 15 days. I do not call it as a time limitation of 45 days in one go, but it is 30 plus 15 days for filing reply. So when the notices are served upon the opposite parties, he can file the reply within 30 days before the appropriate forum. If he, for some reasons, is not able to file the reply in 30 days, he can additionally, on a written application, file reply he can get an opportunity for 15 more days. Thereafter, no opportunity will be provided to file reply. You have to file a revision petition before a superior forum for filing the reply. And all this whole process was made easy for the consumer, that all the evidence would be based on the documents and documents and affidavits. There will be no cross examinations until unless it is required in a specific case, which is quite rare in consumer laws. All the matter would be adjudicated in a time bound manner. So this 1986 act was effective till this time, when there was a need to revamp the laws looking into the current business situations. If you would imagine, see, in 1986 nobody could imagine that in 2000 there would be an e-commerce, there would be one-sided contracts, there would be other activities which is related to e-services. So in 1986 act did not provide for efficient safeguards to protect the interest of e-commerce and advertisements, these kind of things. So in 2019, the government has enacted Consumer Protection Act 2019, which have received the assent of the president, but however is still to be notified. And that act is called Consumer Protection Act 2019, which will be repealing the Act of 1986. And there have been skyrocket changes which have been made in this act. Now, when first I talk about that there has been a skyrocket changes, I would give a brief introduction about what is the Act of 2019, how it is different from the Act of 1986. So earlier, what used to happen was there was no administrative body which would look into the grievance of the consumer. So the consumer was only left with an opportunity that he would straight away file a complaint before the consumer forums of appropriate hierarchy and fight a case. Now, in the Act of 2019, they have established Central Consumer Protection Authority, CCPA as we call it. So the CCPA will be, they would appoint chief commissioners and additional chief commissioners in the CCPA authority, which have the superintendents and general powers to protect the interest of the consumer. And very interestingly, the appeal of CCPA would lie directly to the National Commission. So it is a procedure which shall reduce, I believe it shall reduce all the litigation to quite an extent. And this CCPA has been provided with three major powers, that is recalling of goods and withdrawal of services. Second, reimbursement of prices which a consumer pay to buy a services or a product. And lastly, discontinuation of practices which are unfair and prejudicial or detrimental to the consumers. So these are all the powers which have been granted to CCPA. So what will be the benefit is for a petty amount. What used to happen was a consumer was not comfortable in filing a case. He would not want to, go before a forum, file a case, pay some little court fees, whatever is required, and then contest it for a year or two. When you compare it with the civil litigation, yes, the time limitation is very less. The civil litigation may go on for 10 years or 12 years, but the consumer litigation would get resolved normally in a period of 1 year or 2 years. However, this establishment of central authority would further reduce the time. So if you file a complaint before the CCPA and you have you make a sufficient case, probably I believe that your grievance will be addressed in less than 3 months time. And very interestingly, the appeal, as I told earlier, the appeal shall only lie to the National Consumer Commission. So not everybody would go to the National Consumer Commission for a petty amount. Interestingly, in the Act of 1986, there was no such provisions of establishment of authority for redressal of the grievance. Yet it is the provision of 2000 in the Act of 2019. Also, earlier the provision was if any person is aggrieved by the orders of the commission, they could file an appeal within a period of 30 days, and by paying 50% of the amount or 25,000, whichever is less, in the Act of 1986. However, in the Act of 2019, this amount of 25,000 part has been removed. So if you are at all aggrieved by the orders of the forums and authority, you need to pay 50% of the amount awarded by the court below. So nobody for a petty amount would unnecessarily extend the litigation for an indefinite period of time. Moving on, this authority has also been given the power of engagement of professionals. What used to happen was there were specific or specialized problems for which there was no knowledge to the presiding officers or to the judges. But however, there was no special power for engagement of a professional to look into that issue. However, in the Act of 2019, under section 13, there is a power given to the authority who could engage a professional in the field of medical, in the field of law, in the field of engineering, whatever the field may be, to determine the problems or to determine the dispute. So this is a power which is given to the authority to determine the real problem. So it could resolve all the issues in general for all the consumers. Moving on, the other part was in the Act of 1986, there was no mention about e-commerce, express warranty, or misleading advertisement. There were very less scope for these kind of cases. Under the Act of 2019, the e-commerce has been brought into picture. The seller as well as the a person who is selling goods would be made equally liable for it. There is a provision for express warranty. So if your product is is creating a problem or there is no proper services given during the warranty period, they would also be very strictly liable. There are the earlier act through judicial pronouncement has enhanced the scope, but the statutory provisions were limited. However, now they have increased that scope. Misleading advertisement was something which was a general problem which was being faced by a lot of people. People would complain that there is no resolution to the misleading advertisements, and we are not able to get a redressal of this problem. But now, however, looking to this aspect, even the misleading advertisements have been brought into the picture of Consumer Protection Act 2019. And anybody who's agreed by misleading advertisement, supposedly by seeing a misleading advertisement, you have purchased a particular product, and that product is not giving you a proper usage, which was assured to you through an advertisement, you can still file a complaint. Earlier, this was not within the scope of Consumer Protection Act. Now, when you thereafter, once the authority is established, the three-tier system which we talked about in the Act of 1986 has been reincorporated in the Act of 2019 by changing the pecuniary jurisdiction of the courts. Earlier the pecuniary jurisdiction was up to 20 lakhs. It would go to District Consumer Forum. From 20 lakhs to 1 crore, it would go to State Consumer Forum, and above 1 crore, the claim would go to National Consumer Commission. In the Act of 2019, this pecuniary jurisdiction have been revamped completely. The District Consumer Forum shall have the power to adjudicate a dispute up to rupees 1 crore. So earlier, the cases which used to go directly to the National Commission would now be instituted in the District Consumer Forum. From 1 crore to 1 crore to 10 crore, the case would go before the State Consumer Commission. And above 10 crores, the suit will be instituted before the National Consumer Commission. The court fees, the procedure to determine the claim and court fees has also been changed. So earlier, the court fees and the pecuniary jurisdiction would be determined on the basis of the value of claim. So supposedly, if you have sought for a 20 lakh rupees compensation as for mental harassment, your claim would be determined on that value. But now your claim would be determined only on the value of goods and services for which amount has been paid by you. So supposedly you have paid 2 lakh rupees to purchase a good, and you are seeking a compensation of 30 lakhs or 40 lakhs. So the calculation would be done on that 2 lakh rupees only. So this is a major change in the provisions. I on a personal level believe that this will only overburden the consumer forums, because most of the products would not exceed the amount of 1 crore rupees. So the district consumer forums, which are already burdened, will again be burdened. But I think there have been certain objections to this, and those objections are being considered by the government, and I hope that the good sense will prevail over them, and necessary recourse would be added in that. But however, till now, whatever in the official gazette has been notified, this is the provision which says that the claim value will be the amount value will be the value depending on the amount which is paid as goods and services. Now, earlier, mediation was not the prescribed format in the consumer laws. Mediation and arbitration or mediation is or counseling is the most proactive method followed by judiciary at all levels, including the high courts and civil courts. They would try to redress the grievance through mediation. So earlier there was no provision of sending a matter to a mediation in the Consumer Act of 1986. In the Act of 2019, they have incorporated a specific provision where an issue can be resolved by the two parties by sending the matter to a mediation. And very interestingly, there shall be no appeal which shall be arising out of the order of the mediation panel. So supposedly, if the complainant and opposite or respondent decide to settle the issue through mediation, so they can refer the matter to the mediation panel, which will be appointed by the forums itself. These mediators will include judges, law professionals of these fields. As I told, that there has been a provision of engagement of professionals. Now, moving on, the procedure. What are the changes of procedure? So the reply time of 45 days, that when the notices is issued, 45 days is given to reply, to file your reply or to file a written statement. So that 45 days has been kept intact. So the intention of the legislature to to adjudicate the consumer issue in a time-bound manner has been reincarnated in this matter, in this Act of 2019. So again, that 30 plus 15 days time period has been again been enacted in Act of 2019. Earlier, what used to happen was that appeal could be filed only within a period of 30 days. So that 30 days period has been increased to 45 days only when an appeal shall lie from the court of district forum to the state forum. What earlier used to happen was that in obtaining certified copies of the record of the orders and sending it across to, normally state commission is situated in the capital of every state. So sending it across from various parts of the country to the capital and to engage a lawyer, it is a little time consuming effort, and 30 days would lapse because the lawyer would also then prepare the appeals, get it signed from its clients, and then present it. So 30 days was felt to be less. So that period has also been reduced, and that period has been increased, and 45 days period has been provided to file an appeal. Interestingly, e-filing, which is gaining a lot of attention across the country, there is a specific statutory provisions which has been incorporated in the Act of 2019, which says the complaint can be e-filed. And e-filing of complaint can be done by the consumers by themselves, sitting at their homes, sitting at their respective workplaces, sitting at wherever on earth they are. If they can file a complaint online. So that is also a provisions which needs applaud of administration or the executive. Now, earlier what used to happen was there was no power of review. If you have read the recent judgment passed by the Supreme Court, which says that no consumer forums except National Consumer Commission has the power to review its own order. So what earlier used to happen was that supposedly if the opportunity to file, if for some reason a person has failed to file its reply in 30 plus 15 days, and there was no power assigned to the district consumer forum, so a revision would be filed to the immediate higher forum. So in case of district consumer forum, it would go to state commission. In case of state commission, it would go to national commission. So there was a need felt that once a revision is filed, and normally what used to happen was that the proceedings of the court below was stayed. So it would again, linger on the process for 6 months or 8 months. So there was a need felt to change the provisions. So the district consumer forum, state consumer forum, and national consumer commission, all three forums have been given power to review their own order. So for supposedly after 45 days, you have not filed the reply, and your opportunity to file reply has been closed by the forum, respective forum. You can file an application under the particular provisions of Consumer Protection Act, specifically stating that this was XYZ was the reason for not filing the reply, and it was beyond the control of the respondents, and therefore I may be provided an opportunity. So the courts or the forums, after appreciating his reasons, can take the reply on record. After, they can also provide costs to the complainant for delay in filing. So this is one of the provisions or the powers which have been granted to come to all the forums at respective hierarchy. And this is, as a practicing lawyer, I feel that this is very important provisions. And as a provision, it would drastically reduce the time limit for adjudicating consumer issues. So supposedly, if there was a stay granted and it would go on for a year or two, it might be reduced by half of the time. So this is a particular provision which has been incorporated in the Act of 2019. Thereafter, I have already spoken about the pecuniary and powers of mediation. Yes, one more important provision was that there was no power of second appeal. Earlier, what used to happen was that supposedly a complaint is instituted before a district consumer forum, the first appeal or the regular appeal would lie to the state commission. If at all you are aggrieved by the order of the state commission, you would file a revision petition before the National Consumer Commission. Revision can only be filed on the grounds of law, that there has been XYZ law which has not been appreciated by the forums below, and only the National Commission would appreciate the revision petition if at all they deem it fit to be entertained. This provision, though it still exists, but in the Act of 2019 there has been a slight amendment to it. The provision of second appeal has been incorporated, which states that if there is a question of law which needs to be addressed, then a second appeal can be filed, but it has to be purely on the question of law, not on the question of facts. If in practicality, if I see this provision would only be determined, the usage of this provision would only be determined when this act comes into practice. because I do not know as on today that how powers of this provisions will be exercised by the respective judicial members. But I feel that the second appeal provision might address the issue of question of law which earlier were not addressed by the forums below. Now coming to that limitation. So limitation earlier in the Act of 1986, the limitation was 2 years from the cause of action. So if a consumer is aggrieved by an act by deficiency in services or defective products and goods, he could institute a complaint within a period of 2 years from the cause of action. This 2 years provisions have been copy pasted in the Act of 2019, and the limitation period of 2019 is still 2 years. If you are aggrieved by the deficiency in goods or deficiency in services, you can file your complaint within a period of 2 years. Yes, and one more thing, as I told you that an appeal can be filed from the District Consumer Forum to State Commission within a period of 30 days. Now from 45 days from State Consumer Commission to National Consumer Commission, a complaint can only be filed within, appeal can only be filed within a period of 30 days. So there has been a difference in time limitation. Earlier it used to be 30 days at all levels. Now from District Consumer Forum to State Consumer Commission, it is 45 days. From State Consumer Commission to National Consumer Commission, it is 30 days. Yes, and additionally, there are some powers which have also been assigned to the consumer forums. Consumer forums can now, exercise wide powers. They can issue award to rectify the errors. They can award financial measures. So, they can give you financial award claim for the deficiency in services or defective goods. They can also ask that if there is a general practice or general class of goods, to stop production of that goods at all. These are the powers which has been given more to the consumer forums, and the scope of consumer forums have been enlarged. The more powers under the Act of 2019 has been provided to them. What earlier used to happen was, if there is supposedly you buy a product online from any of the e-commerce app, and the product is not delivered on time, or the quality of product which was assured to you was not delivered to you. So those particular, in those cases, e-commerce was an untouched subject in the Act of 1986. Now, under the Act of 2019, e-commerce has been given statutory provisions to recourse for their grievances. You could directly file a complaint before CCPA, that is the central authority. You could also file a complaint before the forums for adjudication of the dispute. Other thing was, there were certain contracts which were one-sided. When I say one-sided, this is particular in the case of builders. What they used to do is that on failure of payments, they used to charge 200 rupees per square feet as a compensation on monthly basis. But on the delay of delivery of flats or villas or property, they used to give you a compensation to the tune of 5 rupees per square feet on a monthly basis. Those one-sided contracts, there has been specific provisions in the Act of 2019 where these one-sided contracts would be also dealt by the consumer forum. So earlier, if there was such dispute, you would go for declaration before a civil court. Now the consumer forums would have power to deal with the issue of one-sided contracts, and the consumer forums would also have the power to award necessary compensation to the consumers and imply costs on the builders for putting those one-sided contracts in their agreement. So this is something which will help property purchasers and the dealers who were earlier very afraid of getting into real estates and buying flats and villas. So those powers have also been provided to the consumers in the Act of 2019. I very personally believe that this Act of 2019 is very extensive. It covers most of the modern aspects of consumers, including e-transactions, including e-commerce, including fraud by banks, including fraud by builders. And it's an extensive act, and I believe that there were certain lacunas which was there in the Act of 1986 by the virtue of time redundancy has been taken care of in the Act of 2019. So to my research, I believe that this act will be notified in 2020, and consumer laws is a particular field which would be booming in the modern times. So this is the brief overview of the Consumer Protection Act 2019. There are certain judgments also, though those judgments are based on the Act of 2019, but those judgments are some landmark judgments on the issue of Consumer Protection Act. So should I inform those judgments to the audience?
Sure, you should.
Yes. I would be, putting those, I will send the citations to you. So if any person required the citation, they can get it from you, or I would also place it on my LinkedIn profile. So the first judgment is the judgment of Om Prakash versus Reliance General Insurance, which is a 2017 judgment. It says that an insurance company cannot reject the claims on technical grounds. What used to happen was that in case of theft of a vehicle, a registration of FIR is a mandatory provision for getting the claim compensation from the insurance companies. Due to certain aspects, there was sometimes delay in registration of FIR. Under this judgment of Om Prakash, if there is a delay in FIR and the delay is justifiable, the insurance company cannot reject the claims on technical grounds. Second judgment which I would refer is the National Insurance Company versus Hindustan Safety Glassworks. It is also a 2017 judgment which says that in a dispute concerning a consumer, it is necessary for the courts to take a pragmatic view of the rights of the consumer, principally since it is consumer who is placed at the disadvantage. The provisions of the limitation in the act cannot be strictly construed to the disadvantage of a consumer. So, though the limitation of 2 years, which has been prescribed under the Act of 1986 and also been provided in the Act of 2019, has been asked by the Supreme Court to be considered in a liberal manner. So supposedly, if there is a recurring cause of action, so the limitation would not run very strictly. The recurring cause of action means if you have been regularly put to a disadvantageous position because of the act of the respondent, so the limitation would be recurring in nature, or the cause of action is recurring in nature. Third is Pratibha Pratishthan versus Manager Canara Bank. It says that a trust is not a person and therefore not a consumer. So a lot of time what happens is that society, the buyers of the flat forms a trust, or there is the person who is a trustee in an organization used to file a consumer complaint. So the law has been very strictly propounded that trust is not a person and therefore it is not a consumer in the definitions of consumer. Fourth is Mar MGF Land Limited versus Aftab Singh. It says, it is a very important judgment which says if there is an agreement which has an arbitration clause, the consumer forums still will have the powers to adjudicate the dispute. Earlier, the defense which is normally taken by the corporate houses, insurance companies and builders is that there is an arbitration clause placed in the flat buyer agreement or in the insurance purchase agreement, and the recourse would be to opt for an arbitration for adjudicating of the disputes. So the Supreme Court again came to the rescue of the consumers and specifically said that an agreement which is an arbitration clause, the consumer forum will still have the power to adjudicate those disputes. Fifth is Ajay Nagpal and others versus Today Homes and Infrastructure Limited. This is a National Consumer Commission cases which say that that RERA filing a complaint in RERA would not bar filing of a complaint under the Consumer Protection Act 1986. So after the promulgation of the RERA Act, the consumers have the power to file a complaint before the RERA authorities, RERA tribunal, as well as in the consumer court. So in the beginning, there was a lot of confusion that the principle of res judicata will operate, and once the complaint is filed before the RERA authorities, similar nature of complaint cannot be filed in the consumer complaint. Clearing this error, it has been very specifically said that mere filing of complaint in RERA will not bar from filing a complaint in the consumer forums. It has been very specifically, in the ratio it has been held that commission that under the provisions of 1986, it is not inconsistent, rather it is supplemental, and only the power of giving a temporary relief to the buyer has been taken away by under the section 79 of the act, under the 79 of the RERA Act. Therefore, though both the acts are supplemental to each other, and there shall be power there shall be an authority given to the consumers to file cases in either of the forums. Sixth was Dr. M. Kocher versus Ipsita Seals. It's also a National Consumer Commission judgment, which says that if there is no cure or no success in treatment by doctors or hospitals, that would not be treated as to be treated as deficiency in services. So normally what used to happen was, supposedly you are getting treated by a doctor and he fails to cure you properly. So people used to straight away file a consumer complaint before the appropriate forum. So coming to the rescue of the doctor this time, the commission specifically said that if there is no cure or there is no success in getting the disease treated, it would not be treated as deficiency in services, and it will not fall within the purview of unfair trade practice or deficiency in services. Seventh is Manu Solanki versus Vinayak Mission University, which says that except coaching institutions, except all the educational institutes, except coaching institutions will not be covered under the provisions of Consumer Protection Act. So people, there are certain class of people who had started abusing the Act of 1986 and used to file a complaint against the schools and colleges if their children do not secure a particular percentage after being assured high quality of education. They used to file a consumer complaint stating that there is a deficiency in service by those particular institutions. So the National Commission, coming to the rescue, said that educational institutes will not be covered under the Consumer Protection Act. Only coaching institutions, since they impart services, will be covered under the Consumer Protection Act. Moving on, next, Lakshmi Engineering Works versus PSG Industrial Institute. It is one of the very old judgments of 1995 by the Supreme Court, which normally the defense in a consumer matter is that a consumer has purchased the goods or services for commercial purpose. So under the laws of 86 and 2019, commercial, if a person has purchased a particular services or goods for commercial purposes, it will not be covered under the Act of 1980, under the Consumer Protection Act. You have to show that you are consuming the services. So consumer is consuming the services or consuming the goods. So if you could show that you are the final user of the goods, and it is not being bought for reselling or to gain financial gains out of reselling or selling it again or providing it further in the market, only then you would be covered under the Consumer Protection Act. In this particular judgment, it was held that whether goods bought by a person are for a commercial purpose is a question of fact, and it should be decided by taking into account all the facts and circumstances in each case. So there is no there are normal 5 or 6 terms and conditions which would quantify whether a person is a consumer or not. So the Supreme Court came rescue for the consumers and held that it would be depending on the facts and circumstances of each case. It would not be a general checklist principle on depending on 5 factors a commercial usage would be determined or not. Next is Super Computer Center versus Global Investments. It is a 2006 judgment. it is also, I believe that it is important judgment. It says that even if there is a product which has been purchased for commercial purposes, say computers, however, in the duration of warranty, the product suffers from some lacuna, so they will be treated as consumers only. It says that commercial use of certain products is still, and the complaints is still maintainable as the defect period has arisen within the warranty period, and thus the purchaser company comes under the definition of consumer under this act. And lastly, 10th is Assurance Company Limited versus Hilly Multipurpose Cold Storage Limited. This is a very recent judgment of 2020, wherein the Supreme Court has held that the time prescribed for filing a reply to the complaint under Section 13, subclause A of the Act is mandatory in nature and not merely directory. So there was a litigation before the Supreme Court which says that the time limitations of 30 plus 15 days of filing reply is merely directory in nature, and power should be given to the respective presiding officers to extend the time limitations for filing reply. The Supreme Court, larger bench of the Supreme Court, clarified this aspect and said that those directions or the provisions of the statute are mandatory in nature and not directory, and therefore the time limitations has to be strictly adhered to in the consumer matters. So these are some very important judgments which I feel gives you right to the consumers to put forth their grievance before the forum. I personally feel that the consumer should, even for a very little dispute, they should approach the forums for redressal of the grievances, because that will ultimately be helping us in gaining quality of goods and services. Once the manufacturers and suppliers are aware about the fact that the consumers are aware of their rights, and they would be filing complaints against them if a substandard good or a product which is not of, or services which is not of an appropriate quality is offered to them, the quality of market in particularly in India would improve, and with this quality there would be a better standard of living. So I believe these are the consumer disputes which should be should be filed in all appropriate forums as and when necessary. And I believe that in the coming, after the act is notified in the official gazette, consumer laws would be probably one of the very booming field in the coming future, because since there has been creation of multiple authorities like CCPA, consumer forums, also the powers of RERA has been set aside, and it has been told that consumers can file complaint in either of the forums. So that ways they would have enough power, then there would be enough litigation in this particular field.
Right. So should we start away with questions? There are a lot of questions in the chat, as well as I have a few in my mind which I want to ask.
Certainly. I'm waiting for that.
Sure. So, I mean, drug control is considered to be an important form of consumer protection. Right. So, your views, especially in the light of COVID-19.
See, all the laws relating to drugs are altogether different. Those come within the purview of medical laws and approvals of FDA, FSA. It is not related to consumers. What is related to consumers is that supposedly you have been prescribed a particular drug, and that drug includes XYZ component for treating your disease, and those has been manufactured in a very substandard quality. So those will be covered under the Consumer Protection Act. Per se drugs would be covered under the food safety laws and the laws which would require the authentication of drugs to be brought in the market, not within the purview of Consumer Protection Act.
Right. And The next question would be how has this area of law been affected by COVID-19? Nitish, are you there? I think there's some network issue with Nitish. Nitish, are you there? I think we lost connection. Yeah, Nitish, I can see you.
I'm really sorry, there was some connection error. Can you hear me now?
Yeah.
Yes, tell me. I missed your question. What was it?
Oh, my question is about like how is this area of law been affected by COVID-19?
See, COVID-19 has an impact on business across the globe. Every field, what used to happen was in case of accidents, there were intimations to the insurance companies looking to the case and fact to fact basis, used to either, settle their dispute or settle the claim with their consumers, or they would reject their insurance claim. So the insurance claim would then be filed before the consumer forums, which are not being done now because there are no vehicles on road. There would be no accidents, and then there will be no intimation. Also, people used to shop various products from the market, but that shopping activities has been restricted owing to the COVID-19. And once supposedly market is selling 100 products a day, at least one product would have some manufacturing defects or manufacturing should be some shortage of quality of that product. So they would be approaching the consumer forums. That has not been done today. But I believe these are all temporary obstacles, and once the things normalize, lot of new litigation will be brought into market.
Okay. So next question that I had is, just give me a minute. So the next question is, do you think that medical negligence is a liability under the Consumer Protection Act? Many think otherwise. What are your views on this?
Medical negligence covers 30% of the litigation in consumer forums, and it is one of the most approached reasons for consumer forums. The medical negligence is a very wide term. So supposedly, if you are suffering from any disease and there are 10 checklists which needs to be done for rectification of your disease, for to get you cured, and that has not been done by the hospitals, due to which supposedly during an operation you suffer from a permanent disability, or you have been not treated well, due to which there is a delay in recovery, owing to the fact that there has been no proper treatment assigned to you by the hospitals. Those are all medical negligence. The law of consumer protection is very, very strict for particularly medical negligence medical practitioners, and has been very, very favorable to the consumers. uh, I have read so many judgments where huge amount of compensation has been awarded to the consumers. Up to awarding a compensation to 50 lakhs, 70 lakhs for medical negligence to the consumers. So medical negligence is a very broad field. Yeah, many things it is otherwise, but it has been covered under the Consumer Protection Act. There have been huge judgments by the Supreme Court, by the NCDRC, by the state forums of various states, providing relief in cases of medical negligence. Yes, the criteria is that the consumer should be able to, explain in the complaint that the medical, or should be able to prove beyond reasonable doubts that medical negligence was attributable to hospital, and because of that he has suffered some temporary or permanent disability.
Right. So let me just take questions from the chat. Is the consumer law really exist? As a lot of consumer complaints cannot be answered.
See, to an extent, I believe your query might be right, for the reason that if you still go on logging complaint into the online portals, there will be no records. Those complaints are still way to go, and there has still been a lot of problems in adjudicating that kind of disputes. However, if you prefer to file a complaint before the appropriate forums, yes, there are a lot of records, and there will be a lot of relief from the forums. If I talk particularly about Rajasthan and particularly about Jaipur, I think not less than 6,000 to 8,000 complaints are being instituted in the various district forums, and at least 2,000 to 3,000 appeals is being filed in the state consumer forums revisions, and original complaints of at least 500 to 800 original complaints where the jurisdiction is up to 1 crore is being filed every year. So it is very vague to say that the consumer law does not exist. Yes, it exists, but you have to look for the right forums.
Right. The next question is from Dr. V. Sundarsan. Please guide as to how to take up the grievance by a consumer when he does not get the facilities which are inbuilt with packages of the SIM.
I'm not able to understand the question. Does he want that the network issue should be addressed, or what?
I think it's about the network issue.
The network issues, for that if you prove beyond reasonable doubt, you can file a complaint before the consumer forums and district consumer forums, because the quantified amount would be, I believe, less than 20 lakhs. Or you can also file a complaint before TRAI, that is the Telecom Regulatory Authority of India.
Right. The next question is from Shravan, who's a second year law student from Sheshadipuram Law College. His question is, what happens to cases filed under the old act, that is Consumer Protection Act 1986, once the new act came into force?
See, the Act of 2019 is prospective in nature. It is not retrospective. All the complaints which would be filed after the Act is notified, only on those the Act of 2019 would be applicable. All pending complaints, I believe there is the law is very clear that until and unless there is a specific provisions for retrospective applicability of laws, the laws are always prospective. So since there is no provisions in Act of 2019 regarding retrospective applicability, I believe that the pending complaints will be addressed as per the statutory provisions of Act of 1986.
Good. So the next question is from Sushil. He says, how many forums have actually gone in for e-filing?
As on today, mostly high courts and the Supreme Court has gone for e-filing. Certain district courts have also started e-filing. Consumer forums, yes, State Consumer Forum in Rajasthan have started e-filing last week. They have been the platform which is provided by NIC is being used by State Commission for redressal of grievances of urgent matters. Right. So e-filing, and in the Act of 2019, once the Act is promulgated and officially notified in the Gazette, since it is a statutory provisions, I think the administration would have to provide a big change in the infrastructure for filing e-complaints. And in the future, I see that e-filing would be a big, e-filing would be the only case for filing of your complaints. It is one thing which needs encouragement. The consumers, if a consumer can sit at his office and workplace and file complaint for deficiency in goods and services, it would definitely be his first choice. So I think with the Act of 2019, e-filing would be in place.
Right. Then the next question from Sushil again is the advocate doing the e-filing would still have to be registered in the local bar association,
Obviously.
meaning that an advocate in Bombay cannot file in Delhi, right?
See, the Supreme Court says that a particular advocate registered anywhere can practice anywhere in the country. So it is not that if you are registered in Goa, you cannot practice in Jammu. So all you have to do is that you need to follow the instructions of the particular state or particular forums. Suppose it there are 10 checklists for registration of your on e-portal. All you have to do is that particular thing. You can certainly practice interstate also. And this is one of the very interesting part of e-filing. So the e-filing is totally adopted by the courts in India. A person probably sitting in down south can also argue a matter in Delhi. So it is not something that a particular bars restrict you from appearing.
Right. The next question is from Dharmraj. He says there is a provision for punishment, whether the power to punish can be exercised by commission or by the court only.
There is no court. There are always commissions. There are three-tier commissions like district forum, the state forum, and national commission. There are no civil courts in it. Powers under Section 27 has been provided under the Act of 1986, which says that supposedly an award has been passed by the particular forum, whether it may be a district forum or a consumer or a state forum, and those award has not been complied with by the respective respondent. So you can file a contempt under the Section 27 of the Act of 1986, which gives power to the court to punish the person for an imprisonment from 1 month to 3 years and penalty up to 25,000 rupees. In the Act of 2019, the imprisonment is again the same, that is 1 month to 3 years, and the financial penalty has been increased up to 1 lakh rupees. So you have to certainly, if you are aggrieved by the inaction of the respondents, you have to file a complaint or a contempt petition before the respective forums.
Right. So there's this question which is popping up there's a question from a lot of people for the query of jurisdiction. If the seller and the buyer are from different states, the jurisdiction would be where the contract has been concluded, which is generally the seller's state, because it is that state where the communication of acceptance has been concluded.
I think I missed this part in my webinar about the jurisdiction of filing a complaint. In the Act of 1986, the jurisdiction to file a complaint is where the defendant resides or operates. So supposedly, if you have bought a product from an e-commerce app which have their business place of business in Bangalore, you tend to file a complaint only in Bangalore. You cannot file it in Rajasthan. However, one clause to it is if the respondents have an office or a employees in Rajasthan, you can still file a complaint in Rajasthan. So supposedly, if the company has their warehouses in Rajasthan, you can still file a complaint in Rajasthan because the defendant has its office there. Now, under the Act of 2019, this has been completely changed. The place of residence, the three places where a complaint can be filed is, first is place of residence of the complainant. So if you are residing in Madhya Pradesh and the respondent is residing in Tamil Nadu, you can still file a complaint in Madhya Pradesh. Second, where the defendant resides. So if both of the parties resides at the same place, supposedly I stay in Jaipur, the respondent also stays in Jaipur, I can file in Jaipur also. Third is where the cause of action has arisen in part or whole. So if the dispute has arisen in part or whole in a particular place, you can file the complaint there as well.
Right. There are a lot of questions running by. So,
Mayur, your voice, you are not audible. You are not clearly audible.
Am I audible now?
Yes.
Yeah. So, from Sushil, he says, do you foresee that e-filing encourage customers to file complaints themselves, thus lead loss of income to advocates.
No, certainly not. This is not, there is no choice of loss of income for the advocate. Supposedly, if there is a issue which requires legal assistance, the advocate has to be engaged. Advocates can argue online, argue through video conferencing. Filing of complaint and not engaging an advocates are two different things. A consumer can choose to file a complaint themselves and argue the matter themselves. However, they can also engage an advocate, file a complaint online, and argue the matter online if the infrastructure is built that way. So there is no point on saying that business of or the clientele of an advocate will be affected. It will certainly not be affected. Even today, the consumers have the right to approach the forums directly, but 98%, I believe, engage advocates.
Right. Just one more question. Let's take, it's an interesting question, I think. If a private institute takes admission of student, allowing to give exam from home, later after receiving all fees, ask student to come to their institute, which is in another state, on ground that admission was taken based on eligibility to appear from home. Will it be under purview of Consumer Protection Act? If yes, then under the list of students, state or institute state?
See, as per the judgment of the Supreme Court, the educational institutes do not fall within the purview of Consumer Protection Act. But particularly in this case, I feel that there is a deficiency in services at the part of colleges. I believe that you could still try by filing a consumer complaint, and this is a good case of deficiency in services. It will be filed where the defendant resides. So if the college resides in a particular territorial jurisdiction, the complaint will be filed in that particular.
Correct. So I believe Nitish, are you there? Yeah.
Yes.
So
Yes.
one more question: can a dispute of development agreement be challenged before consumer forums? Yeah, I can. Can a dispute of development agreement be challenged before the consumer forums?
Yes, they can be. The developer agreement between the landowner and the developer is a part of a different contract. It is the developer do not fall within the purview of the consumer. The consumer is somebody who consumes the services. But if you are the you are the flat buyer or the land purchaser which is purchasing land out of that deal, then you are in the consumer. If supposedly there is a difference between the land developer and the land owner, it will be subject to civil litigations or the arbitrations.
Great. So let's just, end this session for today here. I thank you, Nitish, for being a part of this great session and enlightening everyone with, your views as well as like the history and about the various jurisdictions that are there in the consumer area. So hopefully I'll have you again sometime soon, and we'll have
very soon. As and when you invite me, I'm always available for you.
Sure. Thank you so much, and thank you everyone for attending this session. I just end the meeting now. Bye bye.